working. Great. I'm Leah Nylen, Bloomberg's antitrust reporter. We're going to have a panel discussion about the merger guidelines, but we were a little too optimistic about their release. So we have changed our panel topic to be about one aspect that is expected to be in the guidelines when they're released, which is the intersection of labor and mergers. So we have a great panel of 4 folks. So you can read their bios in the packet that everyone has. And first thing we're going to do, though, is Dennis is going to give a little bit of an overview of sort of where we are right now with the law, and then we're going to start discussions. If you guys have questions at any point in time, feel free to jump in.
Okay, thank you. I thought it'd be useful to present a brief overview of research in labor markets and market power in labor markets from the view of an IO economist. This is a really hot topic, and there's a lot of research going on. People in this room, Iona has done a lot of work in it. There's a recent issue of the Journal of Human Resources that came out last year devoted exclusively to market power in labor markets. So I thought it'd set the stage for some remarks I'll give at the very end of my introductory remarks, as well as maybe for some of the topics we're going to discuss on this panel. There's been a huge change in the views of labor economists about the presence of market power at the level of the individual firm. I would say 20 years ago, the prevailing view was that most firms faced a pretty elastic supply curve for labor, and that there were some exceptions, one-company towns, maybe nurses, teachers, professional athletes, but by and large, the view was most firms were setting wages in a pretty competitive market. Now, the prevailing view is that most firms have some market power in the labor market. It obviously varies from firm to firm, but that the implication is that it's likely that the wage is going to be set below the competitive level. To me, there's a very close analogy in what's happened in the labor literature to what happened in the industrial organization literature, at least starting at least 40 years ago, where it was widely began to be accepted that firms aren't all facing perfectly competitive situation, but have some market power. Obviously, it differs from firm to firm and from industry to industry. Now, what's been the main sources of information that has caused these labor economists to change their views? Well, there are several. First, there have been numerous attempts to estimate the supply curve, the elasticity of the supply curve with respect to the wage rate facing individual firms. And I would say, by and large, a reasonable sort of consensus is that most firms face elasticity of supply that's less than infinite when they're trying to get labor. And the elasticity, the median elasticity, seems to be pretty high from my point of view, somewhere between 5 and 10. But that still means that there is a substantial, what I'll call distortion, of 20%, depends obviously on the particular firm and industry, between the competitive wage and the wage that's being paid. So that's one source of information. What's another source of information? Well, one important source to me comes from the study of mergers. And I think one of the best studies is the study by Prager and Schmidt, where they look at what happens when hospitals merge. And I think they come up with 2 very important findings. The first finding is that basically nothing happens to anyone's wages unless it's a really big merger. What do I mean by a really big merger? The HHI initially is something like 5,000. The change in the HHI is 3,000. So these are really big mergers. But even there, what they find is that the effect on wages is focused on people who have specific skills, like nurses. Their wages go down, it looks like, by about 7% or so. But for other people who don't have skills specific to the hospital sector, such as cafeteria workers, can't find anything. So I think those are sort of pretty interesting findings. And one of the things I'll say about this paper, they do a very careful job of dealing with what IO economists have known since really Dempsets pointed it out, which is that concentration is endogenous, and you really got to control for the fact that big firms may be getting bigger and more concentrated because they're more efficient. And he tries to do has very clever ways of trying to control for that. A third set of sort of information that's informed the views of labor economists come from no-poach agreements among independent firms. And I highlight the word independent. I'm going to be somewhat constrained in exactly what I say here because I'm involved in an alleged no-poach case. But Gibson studied a particular case that gathered lots of attention, and that was when all the firms, a lot of firms, tech firms in Silicon Valley, entered into what are called no-poach agreements, in which they say, I won't get your employees if you don't try and steal mine. And Gibson looked at this and estimated that the effect of this agreement was to depress wages by about 5 to 10%, depending upon what firm you were looking at. But, and this is a big but, and that's why I stressed the word independent before, that they were independent firms. In the settlement with the DOJ recognized, and I think correctly so, that sometimes there can be efficiency reasons for these agreements, and that if firms are in a collaborative relationship, such as a joint venture, you might not want to enter a joint venture without a no-poach agreement. So there was a carve-out. So I think that's important. That's why I stressed the word independent no-poach agreements. The last source of information comes from what are called non-compete agreements. Now, the difference between a no-poach agreement and a non-compete agreement is the following. A non-poach agreement I view as a no-poach agreement I view as an agreement among independent firms, so it's horizontal. A non-compete is vertical, a firm with its laborers. The person who's done a lot of good work on this is Starr. And here's some of the findings and why they raised issues for labor economists. First, there were a lot of non-competes, 20% of the workforce, it looks like. And here's the puzzling fact. These non-competes, which an economist perhaps can explain as protection of intellectual property, for example, surprisingly were applied to low-wage workers, where you don't think there's a lot of intellectual property. That's kind of surprising. So that's why labor economists say it's probably to affect market power in the labor market. What the empirical evidence shows, and it's mixed, is the following. For doctors and CEOs, it looks like wages go up with non-compete if you have a non-compete agreement. For more general across-the-board workers, which is what Starr was looking at, mixed. Looks like non-competes raise wages. On the other hand, in states where it's very hard or impossible to enforce non-competes, even if it's a contractual agreement, it looks like that causes wages to be be higher, okay, when you can't enforce. The net result, though, of a non-compete seems to be that it looks like it raises wages, which is something that's surprising when you look at low-wage workers. I should mention, and then there are contrasting studies, though, with other results. So in Hawaii, when there was a ban on non-competes, that led to an increase in wages by about 4% among certain high-tech workers. In Oregon, when they banned non-competes, hourly wages went up by 3%. So I'd say the evidence is mixed. I suspect it depends on the circumstances. So let me now tell you what I make of this as an IO economist. First, mergers definitely can adversely affect labor and lower wages. There's no reason to ignore that possibility. Though I stress the evidence, at least from Prager and Schmidt, is that only and also there's someone else, Arnold, who comes to similar conclusions. It's only in limited circumstances, really big mergers, that you're going to see much effect on wages. Second, and this is a point that I'm surprised hasn't been emphasized, if there are distortions in the product market or distortions in the labor market, and all I mean by that is they're not neither is perfectly competitive, then the following is true. A merger that expands output matters a real lot, much more than we usually think. Conversely, a merger that reduces output really causes a large loss. That means mistaken antitrust has big consequences for the economy. Third point I would say is labor market power, to the extent it exists in a particular market, does not imply that antitrust is the useful mechanism to intervene. Let me just give you an example. One standard reason why there's market power in the labor market is because employees have reduced mobility. Why is that? Well, one reason is it's sometimes hard to move across state lines because of licensing laws. Well, the solution to that problem is to get rid of the licensing laws. So it's going to depend on what problem you're trying to fix, and I don't think antitrust can fix all problems. Fourth, my observation, this is similar to what other people have said, is that we focus in antitrust actions a lot on short-run price and short-run wage. But a lot of other things that matter to the consumer welfare, whatever you want to call it, to the economy, and that is long-run consequences. Take doctors, for example. Suppose there's a merger of all the medical, all the hospitals in America, and doctors' wages fall. Well, maybe they can get away with that for a while, but sooner or later, people are going to stop being doctors. People are going to stop applying to medical school, or you're going to get different people applying to medical school. The long-run consequences of investments in human capital seem to me something that I've not seen people pay enough attention to. My last two comments are the following. You might ask, how should harms to labor be evaluated? Well, in, say, a merger case. Well, let me just say monopsony is not limited to labor. You can have monopsony in a lot of other things. I just think in general we should pay attention to monopsony, but still the question is, how should you be measuring harms to the extent they exist? I think we know how to do that. And in fact, I think, for example, the Antitrust Division does it all the time when it looks at an airline merger. It looks at different classes of consumers, and it basically aggregates them. You can do the same thing on the factor input side. I'm not sure that poses a new problem. And I'll conclude with a comment which is similar to the comment I made at the end of the session yesterday, and is actually quite similar to what Frank Easterbrook and Diane Wood said yesterday. There are certainly important policy concerns, income distribution, unemployment, losing your job, that are associated with labor, as well as any merger. But those seem to me to raise problems that are better addressed by other instruments. I'm worried that if you start bringing in all these other values, democratic values, the harm to an individual from losing his job, that it's a bad thing. I agree it's a bad thing. The question is, can antitrust fix that? And if you ask a judge to weigh all these things at the same time, I think you're going to wind up with a mishmash. And antitrust will be set back, and that whatever progress we've made, or we think we've made, in using economic thinking to try and figure out what judges should, help judges figure out what they should do, it's going to be completely lost. You'll lose control over the process. And as Frank said, giving discretion to judges to make trade-offs among many different social values is going to lead to simply a policy, an antitrust policy, that will be, I think, in my view, and I think he would agree, is just going to get out of control and not going to promote anyone's welfare, no matter how well defined. Thank you.
Thank you, Dennis. So, Sanjukta, you've been one of those folks who has been working on this issue. And for those of you who were not here for the dinner last night, she got a very nice shout out from Judge Diane Wood on some of her articles. So why don't you share a little bit?
So thank you so much for having me, and thank you specifically for having me on this panel on mergers. It's fun for me to think about. Most of my research and work has not been specifically about mergers. It's been about other areas of antitrust, and including their intersection with labor. I think maybe it's worth dwelling on that for a moment, because I feel like we've been talking, and I will talk about mergers, but we've been talking about mergers to almost the exclusion of other antitrust rules. I think there are, when we talk about whether antitrust is an appropriate tool to deal with labor market harms, we shouldn't just be thinking about mergers. We should be thinking about other antitrust rules, notably vertical restraints, which have been, the enforcement of vertical restraints has been, that is the bigger really the bigger revolution worked by the Chicago School Revolution, and that has direct impacts on labor. I won't talk about this too much, but there was a great New York Times article yesterday by Leah DePillis, I don't know if I'm saying her name right, on franchising. And it doesn't talk directly about antitrust, but ultimately it is vertical restraints rules that make the sort of control without responsibility of the franchising business model, which labor advocates have targeted for decades now. It makes it an antitrust issue, and it makes it possible, right? The article notes that both the NLRB and the FTC are now interested in thinking seriously about franchising. So I think it's just important that we don't just think about mergers here, but we keep in mind other antitrust rules. I also think the rules on horizontal coordination have an impact on labor in a way that I think will become more clear when I talk further about mergers. Okay, so labor and mergers. I'm going to suggest that we think about labor and merger policy not just from the perspective of what the effect that a merger or a set of mergers has on market concentration and the effect that has on wages, although that is certainly important, and I think all of the empirical and statistical evidence is very relevant. I think we should also think about the merger rules we adopt in terms of their systemic effects on labor unions, on workers. And so here I suggest a more general shift in maybe our thinking about all of these antitrust rules, that we think about them not just in terms of how we would apply a given set of rules in a given adjudication, but how they function prophylactically to create or to not create the sort of markets we want to see, because this is extremely important, right? And this is not a new idea. This is something that I think a way that antitrust thinkers thought about antitrust rules for many decades. And specifically with respect to mergers, what is the effect of a permissive merger policy versus a quite stringent merger policy on the competitive and business strategies that executives, boards are looking at, and that they may even be compelled into, right? So I'll say a little bit more about that, versus the competitive strategies that are open to them in the context of a not very permissive merger policy. What would happen, I'm just gonna ask the question as a thought experiment, if we largely take mergers off the table as a competitive or business strategy, we make them the exception and not the rule, there's still gonna be some situations, what would be the implications for markets in general and for labor in particular? So I'm not going to answer those questions exhaustively, but I'm going to suggest that we think about those questions. I also want to take a step back a little bit from this discussion because we've talking about mergers a lot, but we've been having various debates about rules, standards, and goals, and I want to at least agree on the subject matter that we're discussing if there's disagreement about those other things. And I think that part of the subject matter we're discussing when we're discussing about what antitrust rules should be is what kind of markets do we want to have in society? And given in our economy and in our society, and given that law inevitably shapes markets, what sorts of rules and processes should the law adopt? And I want to distinguish here between considerations that may not be appropriate, I would totally agree, for individual judges in individual adjudications. I'm the last one to suggest that we increase the discretion that our federal judges have. I've argued against that in print. I think we should absolutely adopt bright line rules. But we should distinguish between the considerations that are appropriate for individual decision makers, or for that matter, ALJs, to consider in deciding individual cases that arise under the antitrust laws, and the considerations that are appropriate for us at this conference, or as academics, as advocates, as researchers, as legislators, to consider when we are talking about designing our antitrust laws, because those, and our antitrust processes, because those are conceptually two completely separate questions. And if we're not considering those, then I don't know what the point of having a conference like this actually is, or what the point of at least of legal academic research is. That is our job. I was a lawyer for many years. We're bound by the rules when we're lawyers, when we're a practicing lawyer, but that is not what we're doing here. So we need to think about, we do not have to, entrust a judge to consider some of these bigger impacts that market concentration and permissive merger policy may have on the polity and on society, but it's an appropriate thing for us to consider when we think about what type of rules to adopt. And here, again, coming back to the topic, a permissive or not permissive merger policy is one of these rules that we can think about in this prophylactic way. And also, the empowering and, sort of allowing the FTC to do its job of engaging in competition rulemaking, which I think that the authority is extremely clear from the Supreme Court and the legislative history that they have the authority to do that. I don't think that the arguments and the smoke that's sort of been that has been thrown up in terms of that legal authority has much merit when you actually look at it. And so empowering the FTC to do that, I think, also is another way, a very important way of creating these prophylactic rules. And again, it's different. The reason I'm bringing that up here is that it illustrates the point. What considerations the FTC should take into account when doing competition rulemaking is different from how much discretion we're going to give to individual decision makers. Okay, so I think I've made that point. All right. So what's a merger? A merger is a specific method of expanding the scope of a particular form of economic coordination that has been authorized by law. There's nothing natural about firms in the state of nature. They're not even, people have been innovating and creating in all the context of lots of economic institutions through history, through craft guilds, through mercantile guilds. There's the specific form of the modern firm, shareholder-driven and organized in the particular way that it is, with workers largely divorced from decision-making. There's nothing natural about that. I'm not suggesting that we go back to the guild system. I'm asking us to take a step back and think about what a firm is and what we're doing when we say that the presumption should be that firms have the right to combine. And I want to note that the firm is specifically an antitrust exemption. It is a suspension of competition. You can say that it's crazy to think about, not allowing firm-based coordination. There's actually all kinds of ways. I'm not advocating them. I'm asking us to note them conceptually. You could take the output of a firm that you could keep all the operational integration. You could divide that output, control rights over that output among everyone who works for that firm and let them individually price the output. That would be a more competitive outcome and would potentially replicate the level of competition that the modern business firm displaced when you look at sort of the evolution of the modern business firm. We don't do that. I think it's fine that we don't do that, but I think we need to notice what is actually happening here. I'm not the first one to have this insight. Ronald Coase had this insight. He didn't talk about it in terms of antitrust, but he talked about the firm as a suspension of competition. That is what it is. Expanding that suspension of competition, we need to just be very clear about what we are actually doing and how we treat that differently from other suspensions of competition, including labor unions, cooperatives, and yes, even looser horizontal coordination in the form of things like trade associations. I'll come back to that point. Okay, so mergers are an expansion of the scope of what is already the biggest and strongest antitrust exemption we have, the firm. And some of this, the second point that I would make, so that's one thing I want us to notice about mergers. Then when we talk about efficiencies that may be realized by a given merger, I think we need to consider which of them, first of all, actually are efficiencies versus something else. I'll say more about that. And also, we need to consider how alternatively those efficiencies could potentially be achieved. I'm not just, this point about thinking about economic coordination broadly is not just an academic point. What could we do right now, other forms of coordination that could realize some of the putative efficiencies that specific mergers do allege and put forth? So, for instance, could some of those genuine efficiencies, just considering the genuine efficiencies for a moment, could they be achieved through, for instance, industry-wide standards in various situations? Could they be achieved by a trade association? We have trade associations that do marketing for various industries. You've all seen the milk ads, California raisins, right? Is there coordination through those types of mechanisms that could actually preserve more independent decision-making, which is one of the goals? It's settled law, actually. That's still good law. As far as I know, that's, dispersed decision-making is one of the goals of antitrust law. So should we be considering those? And should we, in any new merger guidelines, be considering a safe harbor for some of these alternative forms of coordination, potentially through dispersed coordination through trade associations or industry-wide standards that could achieve some of the genuine efficiencies without the consolidation, and specifically the consolidation in the form of the shareholder-driven firm that mergers currently signify. So I think we need to put that on the table and consider it. Then I think thirdly, the other thing I sort of want to, everything I'm sort of suggesting is things that we should notice. I'm not sort of suggesting, actually complete normative conclusions, because I don't think we've had enough inquiry into these questions. I'm suggesting we look at this and not just sort of labor market concentration, effect on wages, that's important, but that these are all aspects of what we should be looking at. So how many of these putative efficiencies are actually intensified forms of extraction versus actual efficiencies? And here, it's important to first get conceptually clear about what we mean by efficiency. Do we mean allocative efficiency? Obviously, that's undermined by a merger. I don't find that concept actually terribly useful, but to the extent that we're adopting it, obviously a merger decreases allocative efficiency. Everyone has said that. Bork, Williamson, in the Williamson diagram, this is part of what it says. So allocative efficiency isn't an efficiency that's contributed by a merger. It has to be a production efficiency. So what type of production, when are there true production efficiencies? Are we truly inquiring into them? And to what extent are those production efficiencies, in some cases, actually forms of extraction? I'm not saying they all are. I think there's genuine efficiencies. And so I think we should, study this and consider it properly and clearly. But I think that sometimes, specifically when we're looking at price as an index of production efficiency, which is obviously a shorthand we use all the time, and I don't think we should use, because sometimes, often, low prices are not an indication of production efficiencies. They're an indication of extraction. And I don't mean that in just a normative political way. Let me break it down. What is a production efficiency? A technical efficiency means you get more output for the same input. It is technical innovation, where we have seen such technical innovations in history. We live at a time where we're benefiting from much of this. But consider the difference between a machine that allows two workers to produce more at the same quality versus a new institutional or organizational arrangement that pays those two workers less to produce the same amount. Those are not the same thing. The second thing simply is not a technical efficiency. I'm not taking a normative position on that. You can, I suppose, have the position that that's a good thing and that we should drive wages down to subsistence levels. I do not think that. I do not think many people would say that they think that, even if they do. But I want us to notice conceptually there is a difference. And the same thing applies when a merger leads to greater bargaining power with respect to other firms that are input suppliers or distributors or whatever, right? Firms in adjacent markets that you're bargaining with. If you ultimately even get lower prices, which we know we often don't because instead those savings go up to shareholders, but even, or executives or whatever, but even when you do get lower prices, right, to what extent is it coming from superior bargaining power with respect to suppliers, distributors, whatever, right? Because obviously, if you now have a, we should look at it in individual cases, but often you have more bargaining power if you're now a much bigger firm and you have a much bigger market share, and you're much bigger with respect to your trading partners in adjacent markets. So we need to distinguish between true technical efficiency and extraction, both on the labor side and on the small firm side, and not because we just care about small firms and we romanticize them and it's some like nostalgic ideal. Those small firms have workers themselves. So if even the supposed wage premium of large firms, we need to look very carefully at, because to what extent is that a wealth transfer from the workers of other firms to the workers of large firms, to the extent there even is a wage premium, right? So these are all things that I think we need to just take a step back and think about when we think about merger policy and workers, and I suspect I'm over my time, but I also want to include in things that are not efficiencies the direct transfer that merger policy considered at permissive merger policy at a systemic level entails from essentially productive sectors of or productive arms of the firm, and therefore ultimately from workers, to shareholders and deal makers, because that is a systemic, I mean, we can sort of talk about it in this individual way that seems like we're pointing fingers, but if we consider it systemically, it's an important element. So I just want to maybe very briefly quote from Josh Mason, an economist that I think that maybe antitrust folks should pay more attention to, and he has this nice essay on, various economists and social scientists have been talking about share buybacks as a form of this type of extraction and wealth transfer from workers and from production in general to the financial sector, right? But thinking about M&A itself as this type of transfer, and he points this out, and he says that when you look systemically at sort of corporate finance, he says that quantitatively acquisitions are especially important. And it's specifically cash out. So we gotta look at what the type of deal is, right, as well. Of course, when acquisitions are paid in stock, the total volume of shares doesn't change. But when they're paid in cash, it does. In the aggregate, when publicly traded company A pays $1 billion to acquire publicly traded company B, that is just a payment from the corporate sector to the household sector of $1 billion, just as if the corporation were buying back its own stock, et cetera, et cetera. So we're transferring from producers to savers at a systemic level, and that's what's been, again, you can have different views on that, but that's what's been critiqued with respect to share buybacks, and it is, in that sense, a wealth transfer. Finally, I just want to very, very briefly note that point I alluded to in the introduction is if we think about mergers and acquisitions in terms of this sense of, and merger policy in terms of this sense of prophylactic rules, what are the competitive strategies and tools that are on the table for a CEO, for a board, right? And sometimes, I mean, if you have taught corporations or business associations, as I have, then you read all kinds of cases with your students where the board doesn't want to do the deal. No one who's running the company wants to do this deal. Their hands are tied by the pressure that this set of rules creates, or at least their hands are strongly guided toward doing deals where maybe, we should reconceptualize their primary job is to be a steward and a manager of certain productive assets. That's the point of the firm. We have a very, very illustrious exponent of the theory of the firm in the room. The theory of the firm is supposed to be, the firm is supposed to be about making the best use of productive assets. We've decided as a society, giving this over to managers and CEOs and boards is the way we want to do that. So if that is if that's the goal, would it be useful to have prophylactic rules that actually prevent, that channel their activity toward doing precisely that and not being forced to do deals that often do not benefit anyone?
Thank you very much, Sanjukta. Felix.
Yeah, so hi. Thanks a lot for including me in this panel. I'm going to touch upon a couple of ideas that already Dennis and Sanjukta touched upon. So before speaking more about how we could or should kind of include employment into merger enforcement, I'd like to kind of very briefly highlight the key difference between when we think about the welfare effects of mergers on consumers and workers. So I think the potential harm to consumers from a merger is typically going to come from a lessening of competition. And so in that case, if we want to have a policy that kind of prevents consumer harm, if we're going to focus on that lessening of competition, that's going to pretty much get us there. For worker welfare, I think that it's kind of a little bit more complicated because we have some of the harm to workers from a merger that can come from a lessening of competition, but at the same time, it could be that there is, for example, merger-induced offshoring or perhaps also kind of merger-related efficiencies that relate to employment that might harm workers, but that are not kind of due to a lessening of competition. So as I show in a paper that will be talking about a little bit more in a couple of minutes, even when a product-market merger leads to a substantial decrease in welfare from a lessening of competition, it could be that in this case now that I'll talk about, these other welfare effects kind of are in the different direction and kind of at least as large in terms of magnitude and kind of could plausibly change which decision is better for total domestic surplus. Now, we may not think that this should be part of the mandate of competition enforcers, but people affected by this, they're going to really care about this. So as Timur said this morning, kind of the people in Scranton might not only think about kind of what's coming from the lessening of competition, but kind of the overall welfare effects of a merger. And so if we want to maintain kind of political support for pro-competitive merger policy, I think that we at least need to show that we're trying to address these other issues as well and kind of make sure that in terms of distribution, there aren't kind of very strong losers and very strong winners of a pro-competitive merger policy. Some may argue that kind of the solution is going to be to have more of a total domestic welfare standard. What I would like to do instead is to kind of illustrate in a particular case how competition and non-competition effects of a merger may be in conflict, and then how we could perhaps kind of marginally extend the existing paradigm to still address these things. Okay, so with multinationals, merger-related production relocation decisions can become really important for the effects on workers. Let me give you an example. Let's suppose that we have kind of a firm A and a firm B, and they're both product market rivals, and they both produce exclusively domestically, let's say in the US. And kind of without going into too much detail, let's suppose that we have the choice between two policy options. We have an anti-competitive merger here between firm A and firm B that's going to harm consumers a little bit, harm workers a little bit. And the alternative, let's say in this case, is that they don't merge. Firm A is going to offshore all of its production to abroad, leaving kind of consumers unharmed, but harming domestic workers a lot. So should we prohibit that merger? Well, if our standard is to kind of prevent harm from a lessening of competition, I think it's pretty clear we should prevent that merger. If it's going to be some kind of a total domestic surplus standard, then that answer might be a little bit less clear. Now, to a certain degree, and I want to disclaim that at the beginning, I know very well that that was not the consideration in the case, but to a certain degree, that was kind of the economic trade-off at play in the Whirlpool-Maytag merger. In a recent Stigler Center working paper, I studied kind of this case in great detail, and I tried to quantify these different forces at play. Now, I know that quite a few people in this room and kind of even on this panel have thought even more about this case than I have, but let me give you kind of like a very quick overview of it. So basically in 2005, Maytag was the #2 clothes washer manufacturer in the US. I mean, they did other appliances too, but I'm going to focus on clothes washers here. And they were kind of looking for an acquirer because they weren't doing that well financially. The Chinese appliance manufacturer Haier, that wasn't active in the US market at the time, had made a bid for Maytag. And kind of rumors have it that their plan was to access the market through buying the brand and the supplier network of Maytag and then kind of offshore production to China. Now, shortly thereafter, Whirlpool, the number one in the market, kind of made a rival bid for Maytag. And ultimately, the Department of Justice unconditionally cleared that merger, citing kind of potential entry by rivals as being a sufficient constraint on Whirlpool and Maytag, and showing that they couldn't harm consumers from that. So what I do in the paper is that I use kind of a lot of data on products, on consumer purchases, on production locations. I model how kind of product quantities map into the jobs in these different production locations with an empirical entry model and a model for the number, these numbers of jobs, and a merger simulation to kind of compare these two acquisitions. As I said, I'm not suggesting that that was the trade-off that anybody had in mind at the time. The point of this is much more to think about, is it potentially conceivable that if the consumer surplus effects go very strongly in one direction, kind of other effects might be equally strong and kind of push that decision in another direction. So what do I find? Whatever I do, this merger turns out to be really bad for consumers. I try to look at the incentives for rivals to launch new products. Those barely moved. I mean, they did enter, but not because of that merger. And it led to very important price increases and consumer harm. Next, what I do is that I try to calculate how the number of US manufacturing jobs, in particular kind of in the clothes washer manufacturing sector, differs in these two scenarios. And what I find is that actually there are kind of more jobs after a Whirlpool acquisition than after a Haier acquisition. And so with these estimates and the estimates on consumer harm, I can kind of try to compare the two. And I try to basically see how much consumer surplus, if we compare these two things, would we be willing up to save a domestic job? And the number that I come up with is something like between 100 and 200,000 US dollars per job per year, which if we think about the literature on what jobs are worth to local labor market isn't completely crazy. So the thing that this shows is that kind of when multinationals are involved and they can choose to move production outside of the jurisdiction and may do this because of a merger decision, including workers into merger control can actually potentially change the total domestic surplus effects of like the two options. In this case, kind of it moved in the one direction. It could have also completely be in the other direction. Now, there's a second difficulty that I want to kind of briefly touch upon, and that was discussed already before. I'd like to talk about merger-related efficiencies. So in many cases, merger-related marginal cost efficiencies are going to come from a more efficient organization of production. And that can entail job losses. So let's suppose that, again, we have firm A and firm B, and that firm B has a production technology that uses fewer workers and more robots. And let's suppose that kind of firm B plans to roll out its production technology to firm A after the merger. Now, let's also suppose that those are kind of product market rivals, and that only because this more efficient reorganization of production, this is actually not going to lead to consumer harm. So then these merger-related efficiencies could make consumers better off, but in this case, at least kind of partially at the expense of workers. Again, the harm here does not come from a lessening of competition, but kind of from other considerations that are at play. So what should we do if we want to consider workers in merger control? And should we kind of continue to kind of narrowly focus on the welfare effects from preventing harm from a lessening of competition and kind of ignore everything else? Should we think about like a total domestic surplus standard? In my opinion, and kind of this is going to be policy conclusion that I draw from the research, but that is not kind of immediately a result of the research. We should aim for we should aim for a standard that continues to prevent welfare losses from substantial lessening in competition, and kind of call it a preventing harm from the lessening of competition plus approach, where we kind of slightly modify this in the sense that, so if we wanted to adapt a sort of total domestic welfare standard, that would actually come with a lot of problems. So one thing that is kind of outside of the model here is that when it comes to workers in offshoring, differently to consumers, there might actually be a trade-off here between foreign and domestic workers, and this could kind of kick off an international spiral of protectionist merger enforcement, and we probably don't want that. When it comes to employment-related cost efficiencies, I think that kind of discounting them only because they also hurt workers might not be the greatest idea, because, I mean, as we heard from Chad yesterday as well, like productivity is kind of important, and if we're going to kind of prevent any type of reallocation just because it could also hurt workers, that might kind of create a problem in the long run. At the same time, completely ignoring everything that's not related to a lessening of competition might be an issue as well, because people are going to care about these effects, in particular kind of workers that are probably individually going to be hurt much more than kind of on average the average consumer. So if we want to have public support for pro-competitive policymaking, we kind of need to take this into account. So what could we do instead? I think there are going to be cases where kind of all of the welfare effects go in one direction, then we can just ignore this and we can just continue going for the pro-competitive decision and do what we know how to do. That includes product market mergers. That obviously also includes labor market mergers where there are changes in monopsony power. Now, in cases where these welfare effects go in different directions, I think that we should still kind of go for the pro-competitive merger decision, but then we should perhaps think about how we can very deliberately target resources to exactly those populations that may be harmed. And so something I thought was very interesting in what Susan Athey described yesterday as coming out of like the executive order, that there's an increased coordination between different branches of government, and perhaps that is something that could be expanded in merger enforcement, that it is clear like from a particular merger and from a particular merger decision that the antitrust authorities think should be taken, there are going to be some people that are going to be hurt, and instead of just saying, well, in theory we could have compensated them, kind of government tries to use different branches to very deliberately make sure that people are heard here. I also think that the perhaps slightly unpopular branch of empirical industrial organization, at least in this room, like that I count myself part of, can help to quantify the welfare effects of these cases, and can kind of try to help identify in which cases we have other effects that might be important, and where some of these efforts should be directed to. And I think that kind of by fine-tuning our existing approaches, I hope that we can kind of manage to address these very real and important distributional consequences without kind of losing the main target out of sight, which is still to have a merger enforcement policy that tries to go for pro-competitive decisions and create a dynamic and efficient economy out of sight.
Great. So Holly, we've heard a lot now about sort of the research and academic thinking on this. What can you tell us about what the FTC is sort of actually doing in this area?
Yes, thank you, Leah, and thanks very much to the Stigler Center for inviting me to speak. It's a real pleasure to be here. Before I get started, let me just give the standard disclaimer that my remarks are my own and not those of the FTC or any FTC commissioner. So I'll talk about some of the ways the FTC analyzes labor market effects and mergers. But I'd first like to share our thinking about why we think it's so important to do so in the first place, and it relates to what Dennis was describing with the studies. We think the stakes are really, really high here. We see too many workers facing concentrated markets for their labor. In addition to the studies that Dennis mentioned, there's also a recent Treasury Department report on the state of labor market competition, and it highlights that local labor markets have become more concentrated since the 1980s, and it points to recent research that reveals how monopsony power wielded by employers leads to wealth transfers from labor to capital, broadening the wealth gap and creating a drag on the economy. More specifically, we think there's evidence suggesting that decades of mergers have been a key driver of labor market consolidation across industries. The one aspect of the report that we find particularly insightful is what Dennis mentioned, the Prager and Schmidt study, looking at post-merger wage levels affected by hospital mergers. And, the findings are really important. They show that wage losses attributable to those mergers in occupations with industry-specific skills were, definitely present. And the wage effects were most pronounced where the merger substantially increased employer concentration levels post-merger. And there's additional research that Iona, who's here today, has done that found labor market concentration has wage effects in both low-skilled and high-skilled workers. So this type of research is really critically important to our work. It forms the backbone for our analysis, and it clearly shows that mergers that reduce options for employment mean that employers don't have to compete for workers in terms of their wages and benefits, and it leads to lower pay and lower quality of jobs available. Just as mergers in output markets may reduce competition and lead to higher prices, lower quality or less innovation. And, there's mobility effects. Dennis, you mentioned about, well, in some instances you might have higher wages from non-competes that can make these, exacerbate wage effects. But, if workers aren't able to move around, that just makes things even worse. So, that's something we really have to be cognizant about. So, turning to how we look at labor market effects in mergers, Section 12 of the 2010 Horizontal Merger Guidelines provides some guidance. It spells out that mergers of competing buyers, which would be employers in the labor context, can enhance market power on the buy side of the market in the same manner as mergers of competing sellers enhance market power on the sell side. So the analytical framework's essentially the same as on the sell side. We look to what the relevant product and geographic market are, particularly focusing on the alternatives available to employees in the face of a decrease in wages paid by a hypothetical monopsonist employer. But labor markets have unique characteristics that product markets on the sell side sometimes lack, and our analysis needs to be sensitive to that. Switching costs associated with labor mobility might be higher relative to those associated with consumers when they change a product or service provider. And workers also face two-sided matching costs where they and the employer are both looking for a match. Workers are disadvantaged by information asymmetries unique to labor markets. Moving and mobility costs they face, and it makes labor markets even thinner than typical product markets where only one side is choosing. And so that really exacerbates the market power issues you can have in labor markets relative to product markets. Another thing, when we look at labor markets and mergers, we don't feel we need to do any cross-market balancing. The labor is really its own market. So we're going to look at whether the merger might harm labor in any market independent of possible effects in an output market. We don't need to show both harm to labor and a more conventional harm, such as a price increase that impacts consumers. There could be a situation where there's no competitive overlap in an output market, but the merger might nonetheless harm competition in the labor market. And that could happen, particularly in rural labor markets where there be few employers, and they might be, the few employers that are there, they might be making completely different products. So we're definitely very attentive to the special characteristics of markets for labor. But I don't necessarily think it means we're reinventing the wheel. We do largely rely on the same arsenal of concepts, market definition, but their practical application might differ. So it's worth noting that while we're laser focused on labor harms for mergers today, more so than ever, it's not that we've never looked at that. Monopsony concerns generally have motivated our merger challenges at the FTC in the past. Back in 2018, we examined a merger between two blood plasma center collectors, Grifols and this other company, Biotest. We saw that there were these local markets where they were both competing for blood plasma donors. In fact, it was a merger to monopoly in these local markets, and we saw that the blood donors who were going to these centers to earn a little additional income, they were really affected by this merger. They were going to get lower reimbursements for donating their blood, and services went down. So we required the companies to divest the overlapping blood plasma centers in the markets, and we put the companies under order for that. So that's not exactly a labor case. The blood donors, you wouldn't necessarily consider them to be employees, but the legal framework we looked at, the monopsony, monopsony harm there was essentially the same. So, that was a good example of how we look at things. And then in 2020, we investigated a proposed merger between two companies that provide home health care and staffing services, Aviana Healthcare and Maxim Healthcare Services. And we had concerns that the transaction would have an anti-competitive impact in multiple local markets across the country for nursing services and private duty nursing care. And we expressed concerns, and the parties abandoned their merger. Basically the concern was that the private duty nurses had fewer options, and the merger was going to have an impact on their wages. So, moving forward, we're really increasing our focus all the more on harm in labor markets. We're looking for potential harm to labor in every single merger we investigate, to see whether it undermines competition for workers, in addition to competition on the sell side. We're building our capability to collect and access data related to workers and job opportunities, and the things we would look at when we're investigating these transactions. Another good example of where we looked at this was in a hospital merger challenge we brought, the Lifespan Care in New England transaction in Rhode Island. That hospital merger, we filed suit, and they abandoned it shortly afterwards. On that one, we looked at the potential for the merger to cause harm, not just in the overlapping hospital services market, but also in the labor market, skilled medical professionals. After reviewing our analysis in the Bureau of Competition, our commission voted to challenge the merger over concerns in the hospital services market, but the commissioners split on whether to challenge it on the harm to the labor markets. So, our complaint did not include that, but Commissioner Slaughter and our Chair Khan issued a statement, and they made clear that they were prepared to go forward on the grounds of harm in the labor market in that case. And all four commissioners actually confirmed the notion that a merger that threatens harm in labor, it's a cognizable basis to challenge it under Section 7. I'll also mention that the Rhode Island Attorney General's office, who also sued to challenge the transaction, their administrative opinion paid close attention to the labor effects. So our state attorney general's partners are paying very close attention to labor harms as well. One thing I will acknowledge that's a major limitation affecting our merger review for labor effects is the failure of our HSR forum to require filers to provide any information about their workers. So we're at a significant information disadvantage at the merger screening stage because we don't have sufficient information to determine what kind of workers each party employs and where. It's a known shortcoming with the HSR forum, and we're discussing ways to fill that gap. I also think there's much we can learn from some of our international enforcer counterparts. Some, such as in South Africa, they've been very active in challenging anti-competitive conduct in labor markets. They have a much more humanistic approach to competition law than we do, and it's really refreshing to take a look at how they're doing these things. Let me also mention a couple things about remedies and how the Commission writes orders to address concern about current restrictions on workers. As I've previously said, we're taking a really fresh, skeptical eye towards merger remedies, generally because the evidence shows they don't always work out as planned, and it's the public that bears the risk that an illegal transaction is imperfectly remedied in a way that still leads to higher prices and lower wages and the like. But one thing we are doing that I think is going to help is, for mergers that have, where the companies have non-compete provisions in them that impede talent mobility and exacerbate the labor market harm. Any remedy we take there, we're requiring the companies to eliminate those provisions. We have a couple of examples that we've done. 7-Eleven back in 2021 sought to buy from Marathon Speedway a whole bunch of fuel station outlets, and we required a lot of divestitures, and part of the order required them to drop non-compete provisions they had with the franchisees and employees working and doing business at the gas stations. And then we did something similar in a Utah merger involving kidney dialysis clinics, where we prohibited the acquirer DaVita from entering into or enforcing non-compete agreements and other employee restrictions that they had. Let me also mention some of our other important work outside the merger context that I think has implications for labor. Our Section 5 policy statement issued last year makes clear that employers' conduct that is coercive, exploitative, collusive, abusive, deceptive, or predatory or that involves the use of economic power of a similar nature, can constitute an unfair method of competition actionable under Section 5 of the FTC Act. And Spencer Weber Waller, sitting right over there, gets credit for that. We were very grateful to have his assistance. So we've got the statement out, and we've wasted no time exercising it. Exercising our Section 5 authority using that policy statement. We've used it 4 times in enforcement actions since late last year to challenge employers' use of non-compete restrictions, requiring these companies to sign consent agreements prohibiting the use of these non-compete agreements. And we think those consent agreements are just the tip of the iceberg. I think, Dennis, you mentioned how many employees are actually subject to these restrictions. It's really unacceptable, and it suggests that case-by-case enforcement is not an efficient way to go about it. So as I think everyone here knows, we have proposed a rule that would make it illegal for an employer to enter into or attempt to enter into non-compete restrictions with a worker, or maintain a non-compete with a worker, or represent to a worker under certain circumstances that the worker is subject to a non-compete. And it would rescind existing non-compete agreements. the notice of public rulemaking also identifies alternative rules for comment, noting possible differential treatment for senior executives and high-wage workers, and for franchisees with the relationship with the franchisor. The interest in our rulemaking, it's really profound. The window for public comment closed this past Wednesday, and we received over 25,000 public comments, which is just truly amazing. So that was, I do have some sort of miscellaneous reactions to some of what folks said.
Yeah, I was actually going to open it up to anybody. Is there anyone on the panel who sort of wanted to react to something one of the other panelists said? Well, I guess we'll start and then go down.
I had a few reactions. I just wanted to follow up on something Sanjukta said, which I think is an important point. From an economic point of view, the exercise of monopsony power, although it may increase the profits of the firm exercising the monopsony power, that's not an efficiency. Driving down the way classical monopsony works, as probably everybody in this room knows, is you drive down the wage by restricting your labor. And if you do that, you produce less output. And if you produce less output, the price goes up, not down. So whenever a firm comes in and says, I'm really going to slam, my suppliers, including my labor, if it's because of market power in the buying market, that's a harm. That's a deadweight loss. You don't pass it through. I want to distinguish that from another way of thinking wages are set, and that is in a bargaining framework, and in which you're bargaining over the wage and the quantity. That's a more complicated setting. And there it can be the case that output expands. Perhaps wages go down, but maybe you hire more workers. That's more complicated. So I think we have to keep those two separate in our minds. But at the very least, I agree with you. You don't want to have someone claiming the exercise of monopsony power is necessarily an efficiency. The only other thing I would say about looking at labor markets separately, and in some cases that might be justified, but obviously if you're looking at how a merger is affecting, output prices and wages, it seems to me you have to look at them at the same time. I don't know how you can necessarily separate the two. They're so closely related. The only thing I wanted to add about franchisor-franchisee relationships is you've got to be a little careful that you understand that there's a margin in terms of a franchisor creating its own franchisor-owned independent firms. And to the extent you get one or the other out of balance, there'll be a swing to the other one. And I think the FTC got involved in the 1980s. There were a series of cases in which state franchise laws gave great power, and typically there are a lot of franchises and they have a lot of political power, and they get laws that protect themselves. And that then creates an incentive for independent ownership of the for franchisors to develop wholly owned firms. And that actually leads to more efficiency rather than less efficiency. So that just says we don't want inefficient state franchise or laws. But you got to be careful about that margin and their political power.
Sanjukta.
Yeah, thanks. So really helpful to hear everyone's comments. I guess maybe one quick response to the response is on the output and efficiency thing. So I think that, right, I mean, this is an important point. I think Steve Salop and others have argued that there's an output decrease in classic monopsony, as you said, or I think that is what the model says, and then elaborated policy solutions on the basis of that. But I think it's important to also take a step back from the model and look at real life and sort of economic and business history, where frequently an output expansion does not mean more employment, actually. It means if you look at American history, if you look at some industries now, right, it means workers working longer hours right? So there's nothing about output expansion that entails, under our current rather weak labor laws, that employers are just going to have workers work 8 hours a day and just hire more workers. And that is exactly what happened in the turn of the century, that you had children, that's again happening again, by the way, child labor. There's been many stories on child labor. I think you have all seen them in the national press. But even aside from that, we have lots of workers working, way more than 8 or 10 hours a day. So we should not assume that an output expansion means increased employment. The other comment that I just briefly was going to make, it's not really, your comments were very interesting and made me think about it's not really a case, but a case study, the Chrysler-Daimler merger, which is fascinating, I think, to maybe also bring into this conversation because I think we do have to look at corporate law dynamics and antitrust dynamics together in thinking about merger policy. So in that merger, which involved Chrysler, obviously, from my current home state, Michigan, and Daimler, a German company, it turned out when you look at the accounts of this merger, that the fact that the workers of Daimler in Germany had co-determination at the board level, which we haven't talked about yet, labor and mergers, was instrumental in causing the production to locate in Germany. And the fact that, of course, auto workers in Michigan are unionized, but there's a limitation in labor law where you can't you cannot bargain over fundamental entrepreneurial decisions, right? This is a limitation. But of course, workers who are have that type of influence on corporate decision making in Germany do. So I don't have a big conclusion to draw from that, except that I think is very interesting and directly affected a relocation decision, and I think maybe highlights also that at this, not individual judges, but in thinking about how we're going to design the law, we do have to consider how antitrust law interacts with other areas of law, including our corporate law rules and our labor law rules.
Holly.
So on output expansion, meaning workers working longer hours sometimes. I mean, I completely agree with you on that, and I think that, that just goes to show why we have to be super aggressive, in analyzing and potentially challenging mergers that harm labor markets. Because, in a situation where a firm is expanding output and the workers are working longer hours, if you have more firms that are offering the same work for those employees, they can go elsewhere and potentially get better wages. So, I think that's very important. And it's also critically important that in markets like that, we make sure that there are no non-compete agreements. Because, then the employers, they can't go anywhere. They're prohibited by the non-compete. On your point about the, not having a corporate structure in the first place and just doing away with mergers, that was really fascinating to me, and I had an experience earlier in my career. Although I'd spent the vast bulk of my career at the FTC, I did spend 2 years as in-house counsel for a conglomerate corporation that wanted to turn itself into a pharmaceutical company. I mean, it was a pharmaceutical company. It was American Home Products. And when I was there, they wanted to, the whole mission they had was to transform themselves into a pharma company. And the 2 years I was there, the whole time I spent just doing HSR filing after HSR filing. They were just carving off all these businesses, just selling them off. And I thought, oh my, this is just such an incredible waste of time. I mean, maybe it was bad that they had all those businesses in the first place, but what really got to me was I spent the whole second year working at that company on the American Home Products Monsanto merger, trying to get that through. And, a whole year working with, agencies all over the world with the filings. And I come to work one day, and there's a memo shoved under my door saying, the transaction's been canceled, destroy all your files. And so I'm like, okay, that's it. I'm going back. I want to go back to the FTC, which I did. So I don't know what that means. It just got me thinking, though, what you're saying. But I mean, I think for now at the FTC, we're really focused on just protecting competition. We want to be, one of the papers I saw in your packet was talking about, us being referees and calling fouls. And that's really what I feel that we do. And when it comes to labor harm, me personally, I sort of feel a little hampered by the consumer welfare standard, because where's the employee welfare standard? We need an employee welfare standard. So that's.
Okay, great. I wanted to open it up to questions. Steve Salop is the first one I saw. Can you wait till the microphone just so people can hear on the live stream?
I'd like to ask what I consider a bread and butter question that goes directly to what Holly just said. And that is, suppose a merger is predicted to lead to lower consumer prices, but it's going to lead to lower wages because they have monopsony or increased bargaining power in some market. I'll ask this to the whole panel, how do you deal with that, with those facts, with that trade-off? Do the anti-competitive harms to the workers trump the downstream consumer benefits, or do the downstream consumer benefits trump the upstream employee losses, or do you somehow balance?
So I'll start out on this one. Again, this is me speaking in my personal capacity. I think that's very important right now for what I'm about to say. But we look at them separate. I mean, it's not sort of a balancing thing. You have to look at the labor market. It's a market on its own, and we're going to hone in on that like a heat-seeking missile. And if it means their whole merger is going to sabotage, well then, yeah, let's look at what Sanjukta said. Why are they even doing it in the first place?
Does anybody else want to go ahead?
Yes, I actually think this problem has been solved or at least been addressed, not necessarily on the labor side, but think of any merger. Think of any airline merger. And there's an airline merger, and as a result of the airline merger, the merged firm is going to take a plane and move it from route AB to route CD. And that's because there are people who want to fly and can fill up the plane more, so more people will fly. So just the mere fact that the merger is going to lead to a reallocation of capacity within the REIT system means some consumers are going to be harmed and some are going to be benefited. The Department of Justice, at least my experience has been, does trade those off and aggregate things. And it seems to me that to the extent that there are any either benefits or harms on other sides of the market, you have to aggregate everything together. Now, I understand you could also balance. You could say consumer group one, those AB people, they're really important. Those CD people, I don't really care about those guys. And even though more people are going to fly, I don't really care. I mean, you can do whatever balancing you want, but it seems that to a first approximation, what has been done, and does seem reasonable to me as a sort of an outcome of just cost-benefit analysis, is that you aggregate everything together.
Okay, so Dennis, so you're happy to undo Philadelphia National Bank and the Penguin case? You're happy to undo Philadelphia National Bank and the Penguin case and the basic welfare standard by adopting a total welfare standard. Is that correct?
Well, I think it's
Dennis
more complicated. Wait, I think it's a
Dennis
little
and I
more
should say for the rest of
complicated.
you, we are generally debating partners, but today he's my student.
So Steve and I frequently have lunch together. and even though the waiter thinks we're having an argument, we're really having fun. What I would say is if the benefits are inextricably linked to the transaction as they are in an airline merger, I don't know what else to do, and I think what the Department of Justice, or what I would do, which is what they have done, seems pretty reasonable to me. Now, if you're asking me about Philadelphia National Bank, where there are efficiencies outside the market, whatever we mean, well, that's a different question. I think that I can answer easily. No, it's not. So think about output. I make output with labor, okay? I don't know how I can say those aren't linked when I think about them. In the same way as in the American Express decision, even though I disagree with that decision, if markets are closely linked, you have to take them into account. Now, there's a paper I wrote that you've seen, and not every other people, it's in draft form, where I talk about effects in other markets that are complementary, and whether those should be taken into account. As you probably know from me reading the paper, I would say that in adjudication, judges, that would be too hard. But for people at the FTC and the Department of Justice, I think they definitely should look at those and take those into account. And the point I'm making, which is really the second observation I made, is that when markets are distorted, cost-benefit analysis, which is either in the product market or the labor market, cost-benefit analysis knows how to calculate the changes in welfare that result from a policy. And we've ignored that, and as a result, I think, underestimated the importance of getting antitrust correct.
I did want to point out what you were talking about, airline mergers. I think in the past, the Justice Department has definitely done that. If you think about, for example, American U.S. Airways, where they required them to divest a lot of slots and, in their opinion, expanded output. They have made the point in the current Spirit-JetBlue merger that one reason why they did not accept the remedy is because they had no guarantees that if things were divested, they would necessarily lead to flights on the same routes.
Yeah, I should say I've worked on a lot of the airline mergers, not that one, not the JetBlue one. I did work on the American one.
Matt, and then Tim.
Thanks. I just wanted to offer a quick comment about Evan Starr's work, which I think doesn't show that non-competes raise wages, but shows that high-wage workers are more likely to have non-competes than low-wage workers. So I just wanted to make it clear
That's fair. It's a correlation.
Yeah, the evidence is pretty solid, not mixed.
Solid correlation, but that's why I said the results are mixed. It's not as clear-cut as, say, Gibson's result on the non-compete, where he said, I look what happened in Silicon Valley. As a result of getting rid of the non-competes, wages go up.
Okay, just to be clear, there's that doesn't show a causal factor. It's just correlative.
Tim?
I was sort of expecting a longer question from Matt. So I want to offer a comment, but then I had a question. I feel like this conversation with Steve, this back and forth, does make me think that just going back to the theme of this conference, that the idea of cost-benefit analysis overall governing mergers seems like a bad idea and inconsistent with the statute. I mean, the statute doesn't say anything about cost-benefit analysis. Let's just be clear about that. And I know many minds will go there directly, but it talks about competition or monopolization, and it suggests that maybe we're asking the wrong. Maybe the answer to that, to Steve's question, is to think about, the statutory language, and is there a decrease in competition in these, and what's that look like? And maybe that's related to provable harms, but maybe it's not. But the idea we're just going to come up with two numbers and add them together, and that's why the merger is pro or anti-competitive, is crazy. Or it's nothing to do with the language of the statute, put it that way. So that's my view on that. My question, though, I wonder, just getting outside the sort of narrow merger study of labor markets as markets and harms. A colleague of mine at Columbia, doesn't usually do this kind of work, Jeff, he wrote a paper about golden parachutes and their effects on merger activity. And he's interested in the kind of thing that Professor Paul was talking about, which is the kind of mergers that aren't really good for anybody, but happen because of the individualized incentives. And he found a very strong sort of correlation between large golden parachutes and mergers that later on, like high merger activity or mergers that didn't seem to really help anybody. And I wonder if, maybe that's too far away from what we're talking about, but I wonder if there's some way, if anyone has thought about the legal system's ability to think about or conceptualize mergers that really are, harmful and caused by individualized incentives that are involved. It's sort of labor related because as opposed to people losing wages, there's a big payoff involved that's incentivizing the wager. I don't know if anyone's interested in that topic. Jeff Gordon is the guy who wrote the paper.
Yeah.
Maybe no one's interested.
Well, I do think that the less concentrated the market, the less damage that could be done from that sort of incentive.
I thought you were asking a slightly different question, which is a hard question.
Maybe a better question.
Well, so, and I think Vishny and Schleifer did some work on this, which is when they looked at takeovers, they were, and other people have done it too. Oliver, I'm sure, knows this literature better than I do, but my understanding is that some of the takeovers in which then they lowered wages or fired people was a breaking of an implicit contract that they had with workers. And the question is, what is the legally binding requirements of that? And obviously, if it's not a contract and you're at will, you can't do it, but you're destroying a reputation. And the question is, that was this is a literature from about, 30 years ago or something, I don't. Yeah, so that might have been how you were posing the question, and I think what it meant was once you saw all these corporate raiders who could do this, the reputation of a corporation now didn't mean as much as it used to.
So, really brief comment. That's really interesting. I'll look up the paper, but I guess on the general theme of your comment and Dennis's comments as well, I do think it's important to kind of take a step back and consider what's actually happening in these boardrooms and to just be slightly abstract for 1 second. I really like this idea that the economist Gardner Means, who's a very influential New Deal economist, wrote this report called The Structure of the American Economy through the National Resources Committee, I think, in 1939. And he talks about what are we doing when we study the economy? Among other things, we're studying what he called canalizing rules. So I think it's helpful, and canalizing rules, they channel economic activity. They actually channel competition itself into particular directions. Are we competing, on some competition over wages is good, but are we channeling competition to the lowest possible wages, or are we channeling competition toward innovation, R&D? And of course, the argument has been made by many that a tighter merger policy tends to channel economic activity, competition, and investment toward productive activity rather than toward this M&A game. And so, but on the point about sort of individual CEOs and boards, again, a little bit biased by reading the cases that are in your typical corporations casebook, even the friendly deals are, that we then end up classifying as friendly deals, are deals in which many people on the board seem to feel like their hands are tied because there's some shareholder that is looking for a big payout or is looking to mount, or have a takeover bid in the background. That's in the shadow of what then gets classified as a friendly deal. So this is a lot of what's happening, and if you look at those cases, what's driving this, as opposed to someone in a boardroom being like, oh, there's going to be all these merger efficiencies if we merge these two routes. Sometimes that's what's going on, but a lot of times that's not what's going on. And so I do think we need to look at the incentives, as you said, and including how the antitrust rules are affecting those incentives.
Sanjukta.
there certainly can be harm to employees, especially existing employees of the firm, without any increase in monopsony power in the labor market. You can remove duplication that would lead to some employees being firing. You can automate some jobs that were previously performed by workers, either with AI or machines. It seemed like some of the panel mixed these two. I wondered how you think about harm to employees of the firms that are not the result of an increase in labor market power.
You know, on that, one thing I'll say is, you know, thinking about listening, you know, reaching out to labor unions, seeing what they think, you know, how a transaction affects, you know, bargaining that's going on. You know, that I know that's something that we are incorporating in our analysis today. And I think it could potentially pick up some of what you just described. You know.
So how do you think about it? There's harm to employees with no increase in monopsony power. Is that a consideration?
Well, I mean, if they're unionized, we might look at how a merger changes the bargaining dynamics for the union. Does that make sense?
If they're not unionized, how do you?
Well, that you know, that's a different story. I'm not sure, but I don't know. I mean, how would the merger affect their ability to unionize? That's one possibility.
I thought a good question would be, suppose there's unemployment in a region. Should the antitrust authorities take that into account? I would say no, but you know, other people on the panel may disagree. But it seems to me you don't want to confuse macroeconomic policy with antitrust policy. Antitrust policy can only do so much, and what you really want to do is make sure you're promoting efficient production, because eventually that's what's going to win out. That'd be my sense.
I don't completely disagree that, I mean, I think production efficiency is important, by the way. I don't think anyone wants to waste our natural or human resources at this point. And I think so, you know, so I think we have to look at, there's simple cases, right, where, okay, are we running a truck route through northern Wisconsin to get to southeast Michigan? Like, that seems like a total waste. And if we're doing that to preserve employment, that's not a good idea. And certainly we need much stronger macroeconomic policy to support, you know, the Fed has a mandate for full employment. We should maybe all be advocating for that as well. I also think there's a lot of connection between the microeconomic and the macroeconomic. For instance, I think that antitrust policy and the forms of coordination more generally that antitrust and labor law promote can have a real effect on price inflation, because you know, again, Gardner-Means showed that a lot of observed price inflation, for example, in the late 1950s, which was another inflationary period, was actually due to administrative inflation, pricing discretion by dominant firms, rather than driven by wages or driven by demand inflation. So I think it's important for antitrust and the macroeconomic, the law and policy that's dealing with the macroeconomy to actually be in conversation. But I would agree that we're not trying to just sort of preserve employment at all costs. But then it, I think, comes into the picture how often are true technical efficiencies actually driving these things? And maybe sometimes they are, but often it seems maybe they're not.
I will give Felix the last comment, and then we're wrapping up.
So perhaps just quickly on that, I think that you could have some mergers between two firms where, let's say you have a multinational, it buys a firm with a plant in, I don't know, somewhere in Michigan or something, and now that firm also has a plant in a low-cost country. That might affect kind of the bargaining going on between the workers and the firm in Michigan, because now you have an outside option where it's easier to kind of relocate production. Even though that's kind of not necessarily kind of monopsony power and overlap in that labor market, that might still be related to the lessening of competition for these workers. And then the other, and so in that sense, perhaps one wants to think about that in that case. The other kind of automation point and so on, if that's kind of more towards non-competition effects, and that's kind of what I was trying to get at earlier, we probably don't want to completely ignore this because it's going to matter to people, but perhaps other branches of government are kind of more suitable to that and kind of act in together.
Okay. We are actually out of time. I apologize. But please join me in thanking our panel.